Welcome back to the Deep Dive. Today, we're plunging into a really core concept. It underpins so much of UK child law, the welfare of the child.
Hmm.
It sounds simple, doesn't it? Just do what's best for the kid. But as anyone who's looked into this area knows, well, it's anything but simple.
Definitely not.
It's complex, it's heavily debated, and it really is the cornerstone of how courts make some incredibly crucial decisions about children's lives.
Absolutely fundamental.
Now, before we properly jump in, there's a really important note we need to make. This deep dive, it's specifically built upon and informed by educational materials made available by the University of London.
That's right.
We're incredibly grateful to them for providing these resources to students, and we absolutely want to give them full credit for the foundation of this discussion. And just so everyone's clear, this conversation is strictly for educational purposes only.
For learning.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Good to mention.
And also, for all of you listeners who might be, preparing for exams on this very topic, we really want to send you the very best of luck.
Absolutely. Break a leg.
Our sincere hope is that this session helps clarify things and, well, makes you feel much more ready for whatever you're facing.
Yeah, that's definitely our mission today. We're taking these excellent materials and basically pulling out the key insights to properly unpack this whole concept of child welfare in UK law.
Okay.
We'll look at when and how it applies and, crucially, those situations where perhaps surprisingly it doesn't apply.
Right, the exceptions.
Exactly. We'll dive into its various meanings, navigate some incredibly difficult real-world cases that really test the principle. We'll examine the specific checklist courts use, look at the quite strong criticisms leveled against it, consider alternative approaches, and see how human rights law interacts with this cornerstone principle. Everything we discuss today is drawn directly from those shared resources. The goal is to give you a comprehensive understanding that's, well, both deeply informed and practically useful.
Perfect. All right, let's get right to the absolute bedrock then. The heart of the matter. If you look at the Children Act 1989, Section 1, Subsection 1, it states the primary rule.
The big one.
It governs so many court decisions about children's upbringing or their property. When a court is determining a question regarding a child's upbringing or the administration of their property or the application of any income from it, the child's welfare is the paramount consideration.
Paramount, that's the key word.
Paramount, yeah. That single word is absolutely key. It means it's above all other considerations in these specific contexts.
Exactly. And that principle, paramountcy, it didn't just appear out of nowhere in 1989. Its roots are earlier, notably codified in the Guardianship of Minors Act 1971 as amended.
Okay.
But it was a really pivotal case, JVC, that's J versus C from 1970, that really hammered home its significance.
Right, JVC.
JVC 1970 AC 668. This case established that in these particular contexts, upbringing and property decisions, welfare isn't just a consideration, or even the first consideration,
No.
but the sole consideration. It's the single overriding factor the court must base its decision on. The court isn't balancing the child's welfare against, say, the parent's interests equally in these specific scenarios. The child's welfare is the only scale that matters. Let me just repeat that key case name again. JVC 1970 AC 668.
So JVC establishes welfare as the sole consideration in upbringing and property matters.
Got it. So while the Children Act 1989 is, the main statute we look to for most modern child law applications, the source materials remind us that older jurisdictions still exist and they're relevant for context.
They are?
Wardship and the inherent jurisdiction of the High Court.
They do, and understanding them gives you a much fuller picture of the court's historical role, its protective function. These jurisdictions, they originate from a concept going back centuries. Parent patria.
Parens patria.
Right.
It's Latin. It means parent or protector of the realm. Historically, it referred to the crown's inherent power to protect those unable to protect themselves, like minors. While they're less frequently used for common issues now, especially since the comprehensive framework of the Children Act 1989 came in, these powers represent the ultimate fallback for the state's protective role. That concept, again, parens patriae.
Okay, let's unpack wardship first then.
Huh.
What actually happens when a child becomes a ward of court? What does that status involve?
Well, when the High Court makes a child a ward, it essentially takes over ultimate parental responsibility for that child.
Ultimate parental responsibility.
Yes. As the Law Commission noted in one of their working papers, the court effectively steps into the parent's shoes. But interestingly, with powers that are potentially even wider than those of a biological parent, these powers derive directly from the Crown's parents' patria power we just mentioned.
Right.
A key characteristic is that it's a continuing jurisdiction. The court doesn't just make an order and then walk away.
It stays involved.
Yeah, exactly. It retains overall responsibility to oversee the child's welfare for the entire duration of the wardship. Cases like Re-H 1987 1 FLR 128 and Re-S 1988 1 FLR 128 illustrate this ongoing oversight. The court remains involved, supervising key decisions. That's continuing jurisdiction.
Okay, so if the court holds this ultimate responsibility, what sorts of decisions are considered so significant that they absolutely need the court's specific consent before anything can happen? What are these serious issues?
Yeah, the sources highlight several actions that require court consent for award, and importantly, doing them without permission constitutes a contempt of court.
Which is serious.
Very serious.
Ugh.
These typically include major life decisions. The ward cannot marry, they can't be adopted, their main caregivers or where they live can't be changed significantly.
Okay.
They can't undergo major medical treatment or have blood tests, say, for parentage, without the court's direct approval. These are seen as fundamentally altering the child's future or bodily integrity, so they need the court's specific say-so. You can see the importance of consent, particularly in medical treatment cases like Re-R, A minor, wardship, medical treatment, that's from 1991, and also Re-J, A minor, inherent jurisdiction, consent to treatment from 1992. Although Re-J was technically inherent jurisdiction, the principle of needing consent for major medical issues is broadly applicable.
Okay, so who can actually start wardship proceedings? Who can bring a child under the court's wing like this?
Basically, any person with what the law considers a sufficient interest in the child can apply.
Sufficient interest.
That's the term. This could be a parent, a relative, or sometimes even someone like a concerned family friend, depending on the circumstances. Cases such as Re-D, a minor sterilization from 1976, and Re-B from 1987 show examples of who might have sufficient interest. That contrasts with cases like Re-Dunhill from 1967, where the interest wasn't deemed sufficient.
Are there any individuals or bodies who can't ward a child or face restrictions?
Yes, the sources mention some limitations. For instance, the official solicitor can't initiate wardship on their own behalf. And a guardian and ad litem appointed in other proceedings also can't ward a child in their capacity as guardian. Cases like Re-T minors from 89 and AV Berkshire County Council, also from 89, cover that. Local authorities also face certain restrictions on using wardship, particularly since the Children Act came in, partly to prevent them sidestepping the specific statutory procedures for care proceedings.
Right, using it as a workaround.
Exactly. And the jurisdiction itself, wardship, it's quite broad geographically and in terms of nationality. It applies to any unmarried person under 18 who is either a British subject or, interestingly, an alien minor who is physically present in England and Wales, provided they owe allegiance to the Crown.
Physical presence is key then.
Physical presence and owing allegiance, yes. Cases like Re-PGE, an infant from 1965, and Re-BM wardship jurisdiction from 1994 illustrate this test.
So, with the Children Act offering such a wide range of statutory orders, residence contact, all those Section 8 orders, when would a court still actually turn to wardship today? What are its specific uses now?
That's a good question. Wardship still has specific uses where the statutory framework might not quite fit or be sufficient. The sources give several examples.
Okay.
If a parent's future behavior is unpredictable but potentially poses a threat to the child's welfare, wardship might offer broader control than, say, a simple prohibited steps order. That was seen in Ray W. from 1995. It allows the court more ongoing oversight.
Right.
It can also be used in complex adoption scenarios. For instance, if an adoption order is revoked or declined, but the child's welfare requires them to stay with the people who are going to adopt them, wardship can provide continued judicial oversight. Ray K. from 1997 is relevant there.
Interesting. What else?
It's also useful for abandoned children, where there's literally no adult with parental responsibility and the court needs to step in fully. And as we touched on with consent, it's vital in medical treatment cases where parents refuse consent for treatment the court deems necessary for the child's welfare. Wardship gives the court the power to authorize it.
And publication.
Yes, absolutely. The court in wardship has significant protective powers regarding publication restrictions. It can make orders preventing media reporting or identification of children to protect them from harm or unwanted attention. The source materials list numerous cases demonstrating this: MNN, Re-C, BBC v. Rochdale, Re-H, Re-Webster, X v. Persons Unknown, Leeds CCV Channel 4. Reward, showing the court's ability to use wardship to control information flow in the child's best interests, a very powerful tool for protection.
So across all these varied applications of wardship, what's the single overarching principle guiding the court's decisions? It must come back to welfare, right?
Without question, it's the welfare of the child. The sources highlight this repeatedly. Dunn J. in Re D, that's Re D 1977, FAM 158, famously described it. He said the child's welfare is the golden thread which runs through the wardship jurisdiction.
The golden thread. I like
Yeah.
that.
He emphasized it's considered first, last, and all the time. It permeates every single decision the court makes when a child is a ward. Welfare of the child is paramount.
Okay, got it. Now let's shift slightly to the inherent jurisdiction. How is this different from wardship, even though they both seem to come from that same parens patria idea?
Right. The inherent jurisdiction is another aspect of the High Court's historical power, originating from parens patria, but it is distinct from wardship. A key case that helped clarify this difference is Re W, A minor, medical treatment from 1992. Re W.
Okay, re-W, what was the crucial distinction made there?
Re W established that when the High Court is exercising its inherent jurisdiction, the court does not acquire parental responsibility for the child. That's the key difference.
Oh, okay.
In wardship, the court takes on that role. Under inherent jurisdiction, it doesn't. A child doesn't become permanently subject to the inherent jurisdiction in the same way they do in wardship. The court simply exercises this power to make specific, targeted orders concerning the child's upbringing or welfare in particular circumstances without taking over the comprehensive oversight that comes with wardship. It allows for a more limited, focused intervention.
More surgical, perhaps.
In a way, yes. The sources also note that the scope of the inherent jurisdiction has been considered in light of the Human Rights Act 1998. This might impose some limitations or require specific approaches, for example, in Rev S, a child, identification, restriction on publication from 2004 concerning publication restrictions.
So it's still relevant today?
Oh, yes. Despite being a power to be used cautiously, the inherent jurisdiction still shows flexibility in family law. Recent cases show it can be used for unusual situations, like revoking adoption orders where statutory grounds might not quite apply. Cases like ZHV, HS, and ORS from 2019 and AXVBX, revocation of adoption order, from 2021 demonstrate this. In AXVBX, the court used inherent jurisdiction because, essentially, as the judge put it, the order sought in this case is supported by all parties and reflects the factual reality, even without specific statutory authority.
But there are limits. Strong cautions.
Definitely. The sources strongly caution that inherent jurisdiction should be used as a last resort.
A last resort.
Yes. The Court of Appeal in Re-NM, a child, in 2020 highlighted the need for courts to fully analyze whether statutory options are sufficient before jumping to inherent jurisdiction. There's also a significant concern, particularly articulated by Poole J. in Nottinghamshire County Council VLH in 2021, about using inherent jurisdiction simply to authorize depriving a child of their liberty because, frankly, local authorities lack adequate resources or placements.
Plugging resource gaps, essentially.
That's the worry. While the Supreme Court in T, a child, in 2021 confirmed it can legally be used for deprivation of liberty orders in certain circumstances, they echoed deep concerns about it becoming a tool to fill gaps in the care system caused by resource shortages, rather than being used for its intended purpose. So it's a powerful but constrained tool, especially when resource issues are in the background. The quote from the Nottinghamshire case was quite pointed about it not being a rubber stamp for lack of resources.
Right, it's very clear. So it's becoming obvious that while the welfare principle is central, it's definitely not applied everywhere. Where are the limits? When is the child's welfare not the paramount consideration?
This is a really crucial point and one that often trips students up. While Section 1 of the Children Act makes welfare paramount in most decisions about upbringing or property, the definition of upbringing in Section 105 is key here. Welfare is not paramount if the issue of upbringing is only sort of incidental to another primary dispute.
Okay, an example.
The classic example cited is Richards v. Richards from 1984, Richards v. Richards. The House of Lords held that in a dispute solely about which parent should occupy the former matrimonial home, the child's welfare wasn't paramount. Of course, it was a relevant factor.
Sure, it affects the child.
But the primary legal dispute wasn't about the child's upbringing itself, it was about property rights between the adults.
Got it. What about specific laws or situations?
Yes, there are also several specific statutory contexts where the welfare principle is either explicitly limited or simply doesn't govern the decision-making process at all.
Okay, let's list them.
Right. First, when courts are deciding whether to grant leave, that's permission to someone to even apply for a Section 8 order under Section 10 of the Act, welfare isn't paramount at that initial gateway stage. That was confirmed in Re A and W in 1992.
So just getting permission to ask isn't governed by paramountcy.
Exactly. Second, determining child maintenance. Section 105.1 explicitly excludes maintenance from the definition of upbringing. So decisions on child support are not governed by the paramount welfare principle. They fall under other frameworks, like the Matrimonial Causes Act 1973, which requires first consideration to welfare, but not paramountcy.
Different standard.
Or the Child Support Act 1991 scheme, run by the Child Maintenance Service, where welfare isn't the governing principle. Third, the criteria for granting secure accommodation orders under Section 25 of the Act. These prioritize specific factors related to risk of harm or absconding, other than paramount welfare, although welfare is still considered. Cases like RAM, Secure Accommodation Order from 1995, MA Child, Secure Accommodation from 2018, and Ray B, Secure Accommodation Order from 2019 illustrate this.
Okay, what else?
Fourth, applications for financial provision for children under Schedule 1 of the Children Act. These aren't governed by paramount welfare either. Cases like KVH, Child Maintenance from 93, and BVB, Transfer of Tenancy, from 94 are relevant. Fifth, when courts consider restricting publicity that could harm a child, like in media reporting cases. The child's welfare is a key factor, absolutely, but it's not paramount. It has to be balanced against other rights, especially freedom of expression under Article 10 of the ECHR. Cases like Re-HS Minors, RV Central Independent Television, and Re-R Wardship, restrictions on publication, all from 1994, demonstrate this balancing act.
Balancing welfare against freedom of speech.
Precisely. Sixth, local authority services provided under Part 3 of the Children Act, like support for children in need, these are guided by a general duty to promote welfare, but decisions aren't made under the paramount welfare principle. The availability of resources plays a significant role.
The resources point again.
Yes. The sources use a good example. If a child has anxiety about stairs but needs access to a recreational activity, the local authority isn't necessarily expected to fund expensive helicopter travel just for that specific center if a suitable alternative is available elsewhere within budget. Resources can legitimately limit what's practically achievable, even if something else might theoretically be better for welfare in isolation.
Okay. Anything else?
Finally, a simple one. When deciding whether to grant a divorce decree itself, the court's focus is purely on the grounds for marital breakdown, not on the welfare of any children of the marriage at that stage.
Right, that makes sense. Okay, that's quite a list of specific exceptions. Can you just give us a quick summary then of where the paramount welfare principle is most definitively applied? Where does it absolutely rule?
Absolutely. Based on the sources and the structure of the Children Act, the paramount welfare principle is the absolute driving force in decisions regarding applications for parental responsibility, PR. All Section 8 orders, so that's residence, contact, prohibited steps, specific issue orders.
The main private law orders.
Exactly. Also adoption orders, and crucially, when the court is deciding whether to actually make a care order or a supervision order in public law proceedings. However, and this is important for care and supervision orders, the paramountcy principle only really kicks in after the applicant, usually the local authority, has proved the initial threshold criteria have been met that the child is suffering or is likely to suffer significant harm.
So post-threshold.
Post-threshold, yes.
Yep.
So key areas for paramountcy: PR, Section 8 orders, adoption, and care supervision post-threshold.
Got it. So we know where it applies. But what does welfare actually mean in practice? It's not defined in the Act itself, is it? Which seems a bit odd for such a central concept.
That's absolutely right. The Children Act, 1989, deliberately leaves welfare undefined. The intention was to give courts flexibility to adapt to individual circumstances. But yes, it immediately raises questions about its meaning and consistency.
Of course.
Judges have interpreted it very broadly over the years. The sources cite a helpful perspective from Hardy Boys J in a New Zealand case, Walker v. Walker and Harrison from 1981, which is often referenced in UK discussions.
Okay, what did he say?
He said welfare is all-encompassing. It includes material things, a good home, standard of living, healthcare, but he stressed these are secondary. More important, he said, are the less tangible factors. The stability and the security, the loving and understanding care and guidance, the warm and compassionate relationships. Basically, everything essential for the child's full development, character, personality, talents. It's about emotional and developmental well-being as much, if not more than, just the physical
That's
aspects.
a very broad definition.
It is. And more recently, Munby LJ in REGI, Children, from 2012, described it as a welfare appraisal in the widest sense. This means considering a vast array of factors he listed: ethical, social, moral, religious, cultural, emotional, familial, educational, and social environment and community. It really is a holistic approach looking at the child's entire context.
Holistic. That leads to this phrase, global holistic evaluation, which appears in cases like Re-F and Re-G. What does that actually mean in practice? Is this some new test?
Not really a new test, no. The sources explain it's more like shorthand for how judges are expected to approach the welfare analysis. It means looking at the case as a whole, considering the full picture of the child's life and future. And crucially, doing that particularly by having regard to the specific factors listed in the welfare checklist in Section 1.3 of the Act or the equivalent adoption checklist.
So it's linked to the checklist.
Very much so. The complexity of this global evaluation will naturally vary depending on the issue. Deciding, say, where parents exchange a child for contact is simpler than deciding if a parent can relocate internationally with them. But the fundamental approach is the same. Weigh up all the relevant factors using the checklist as a guide to find what's best for this child's welfare in these circumstances.
Okay. Now, the Children and Families Act 2014 added something about parental involvement, didn't it? In Sections 2A and 2B. How does that fit into this welfare picture?
Yes, it did. These sections introduced a presumption into the Children Act. The presumption is that, unless the contrary is shown, the involvement of a parent in the child's life will further that child's welfare. Section 2B clarifies that involvement is broad. It means some kind of involvement, could be direct contact, could be indirect, like phone calls or letters. Importantly, it doesn't automatically mean a specific division of time, like 50-50.
Or just involvement?
Just involvement. The sources note that while this sounds quite significant, courts were largely operating on this kind of premise already in most contact and residence cases. So its practical impact, beyond being a symbolic statement from Parliament about the general importance of parents, might be less dramatic than it first appears.
Interesting. Okay, let's talk about the cases that really push the boundaries and highlight just how difficult applying welfare can be, especially when interests clash dramatically. The conjoined twins case, conjoined twins from 2001, feels like the starkest example.
It truly is a heart-wrenching case that really exposes the limits of simply saying, do what's best for the child. When you have two children whose fundamental interests are diametrically opposed, and one's very existence depends on harming the other.
Remind us of the basic facts.
Conjoined twins, involved Jody, who was described as capable of independent life if separated, and Mary, who was entirely sustained by Jody's heart and lungs and could not survive separation. The hospital sought a declaration from the court that an operation to separate them would be lawful, and crucially, they initially argued it would be in the best interests of both twins.
How did the first judge rule on that?
Well, the judge at first instance actually concluded the operation was in both twins' best interests, even Mary's. His reasoning was that her continued life attached to Jody was effectively worth nothing to her and was hurtful.
That sounds harsh.
Extremely controversial reasoning, and the Court of Appeals strongly disagreed with it. They pointed out, quite rightly, that Mary's life was not worth nothing. More critically, the proposed operation wasn't just a passive withdrawal of treatment, it was an active surgical invasion, legally speaking an assault, which without consent is unlawful. Looking solely at Mary, knowing the operation would inevitably cause her death, it simply couldn't be said to be in her best interests.
So the Court of Appeal faced an impossible dilemma.
Absolutely. A profound conflict. Jody's life versus Mary's life. And the court's duty under the law is to give paramount consideration to the welfare of each child individually. This forced them into a very complex, perhaps unprecedented balancing exercise.
How do they frame that balance?
They essentially put the right to life of each twin onto the scales, alongside what they called the worthwhileness or potential benefit of the proposed treatment for each child.
And the outcome?
The ultimate outcome was that the Court of Appeal permitted the separation. The reasoning, though legally challenging and much debated, was primarily based on giving Jody the chance of a relatively normal life. While Mary's life would inevitably be shortened by the operation, she was tragically doomed anyway, even if they remained joined. The court felt it was impossible not to consider how each twin could potentially exercise their right to life.
So, least worst option.
Essentially, yes. They concluded that allowing the operation, despite the tragic outcome for Mary, was the least detrimental choice when balancing these competing rights and interests. They also reasoned that doctors facing such an impossible situation should have the same freedom as the court to make this choice, framing the operation as the lesser evil. The concept of quasi-self-defense, essentially, defending Jody from the ongoing harm caused by Mary's dependence, was even explored as a potential legal justification.
Quasi-self-defense. Wow. And this case really forces you to think critically, doesn't it? Was it the right result? Maybe, but reached through incredibly difficult and perhaps legally strained reasoning. It just starkly shows the limits and the deep discomfort of applying welfare in these truly extreme life and death conflicts. The source material suggests Activity 9.4 prompts exactly this kind of critical thought.
Absolutely. It's a case that sits uneasily. And the sources provide other examples in the medical context that reinforce how welfare decisions depend heavily on the specific, unique facts of each case, making precedent less powerful than in other areas of law. The Wyatt, a child cases from 2004 and 2006 dealt with incredibly difficult decisions about the best interests of a child with severe medical problems and the question of non-intervention or withdrawing treatment.
What happened there?
An initial do not ventilate order was lifted, but later, as her condition worsened, a declaration that non-ventilation was lawful and in her best interests was successfully sought by the hospital, though she did survive longer than anyone anticipated. It showed the ongoing, agonizing nature of these decisions.
And other cases.
Another difficult one mentioned is an NHS Trust v. MB from 2006. This involved an 18-month-old with a degenerative condition who was significantly conscious and sentient, aware.
Ah, that makes it different.
Totally. Here, the court had to balance discontinuing life-sustaining treatment against the parent's strong wishes to continue, especially for a conscious child. The court ultimately wasn't persuaded it was in the child's best interest to withdraw ventilation knowing it would lead to death, and refused the hospital's application. These cases demonstrate that even within the medical context, applying the best interests or welfare test is highly fact-specific and requires intensely careful individual assessment.
What about when there's more than one child involved in a case, like siblings?
Yes, one final important point on these difficult scenarios, especially when dealing with multiple children, like siblings in a residence dispute. The court must consider the welfare of each child individually. You can't just lump them together or assume what's best for one is automatically best for the others, especially if their needs or relationships or views differ. That principle, each child must be considered individually, is highlighted in cases like Birmingham City Council v. H. A. Mimer from 1994 and T&E proceedings, conflicting interests, from 1995.
Okay, so welfare is broad, undefined, highly fact-specific. How does the Children Act try to guide judges more concretely in determining it in those cases where the paramountcy principle does apply? This is where the famous welfare checklist comes in, right?
Precisely. Section 1, subsection 3 of the Children Act 1989 provides a specific statutory checklist of factors that the court must have regard to. This was a key recommendation from the Law Commission in their reports, Working Paper 96 and Law Com 172. The aim was to improve consistency and clarity in judicial decision-making.
Consistency and clarity.
Exactly. It provides a structure for that global holistic evaluation we discussed earlier. Now, it's important to remember the checklist isn't exhaustive. Judges can consider other relevant factors if needed. And the listed factors are not ranked in any order of priority. They all have to be considered.
And when must it be applied? Is it for every decision?
No, critically, and this is a key point for exams, Section 1, subsection 4 of the Act mandates that the court must apply this checklist, but only in specific types of proceedings.
Okay, which ones?
These are contested Section 8 orders, so residence, contact, etc., where the parents disagree, care orders, supervision orders, education supervision orders, and applications for contact orders concerning children who are already in care. If the court is making one of these specific orders in contested proceedings, they are statutorily required to go through this list of 7 factors. For other decisions, even those governed by the paramountcy principle, the checklist isn't mandatory, though it's often used as a helpful guide.
Right, so mandatory only for those specific contested orders.
Okay.
Let's walk through the list. What's the first point the court must consider?
The first factor on the list is the ascertainable wishes and feelings of the child concerned, considered in the light of their age and understanding.
Right, the child's voice. This gets into that tricky area, doesn't it? balancing what the child says against the court's decision and maybe their potential rights.
It absolutely does. The sources point out there's been some historical ambivalence in how courts have treated children's wishes. Some older cases, like Red DW from 1984, tended to view children as easily swayed or perhaps poor judges of their own long-term interests.
Hmm.
However, other cases, and certainly the modern trend, recognize that a child's expressed wishes can be a very good indicator of their future happiness and stability. Cases like MVM from 1987 and Williamson from 1986 lean this way. Plus, there's a growing emphasis internationally on the child's right to express their views in matters affecting them.
But it's qualified by age and understanding.
Crucially, yes, in the light of their age and understanding. This brings in the whole concept of Gillick competence. Remember that name? Gillick competence. It stems from the landmark House of Lords case Gillick v. West Norfolk and Wisbech Area Health Authority from 1986.
Got it.
This principle, supported by later cases like Re P. A. Minor Education from 92, Re R. Residence Order from 2009, and Re S. A Child from 2010, essentially means that a child, if they are mature enough and have sufficient understanding of the specific issue, can be capable of making their own decisions, particularly about medical treatment, even if they're under 16.
But there are limits to that confidence, aren't there? Especially in medical contexts.
Yes, it's vital to understand the limits of Gillick competence, which the sources detail quite carefully. Even if a child is judged Gillick competent to refuse treatment, the court can still authorize that treatment if it's deemed overwhelmingly in their best interests. That was shown in University Hospitals Plymouth NHS Trust v. B in 2019, and the complex cases around puberty blockers raised fundamental questions about capacity. The High Court in Bellevue the Tavistock and Portman NHS Foundation Trust in 2020 initially expressed serious doubts about whether a child under 16 could truly consent, finding it highly unlikely for under 13s. Although, importantly, the Court of Appeal later overturned this specific finding in Bellevue Tavistock in 2021, stating it was ultimately for clinicians to assess capacity on an individual basis.
So the clinicians decide competence.
Clinicians assess yes, but the legal framework is complex.
Yeah.
The sources also note that a parent with parental responsibility can still consent to treatment even if a Gillick competent child refuses, effectively overriding the child's refusal unless the parent's decision itself is being challenged as not being in the child's best interests. A case called ABVCD from 2021 refers to this continuing parental right, and ultimately, neither a 16-year-old nor a competent child under 16 can refuse treatment if a parent or the court consents. The court retains the ultimate power.
So Gillick competence isn't absolute refusal power.
Definitely not in all circumstances, especially life-saving treatment. And a child's wishes on other matters, like changing their surname after parents separate, are also considered under this first checklist point. Cases like WNA, minor surname from 81, and Re-S from 99 suggest courts give significant weight to teenage wishes on surnames. But again, it's not decisive. The court can refuse based on other welfare factors, like preserving a link to a natural father, as happened in Re-B, change of surname, in 1996, even despite the child's wishes.
Wow, that's a really complex first point. Okay, what's the second factor on the mandatory checklist?
Number 2 is the child's physical, emotional, and educational needs.
Needs. Seems straightforward, but probably isn't.
It's broad. It covers basically everything necessary for a child's healthy development. Courts frequently consider factors like the importance of keeping siblings together where possible, although this isn't an absolute rule if it's genuinely not in the children's individual best interests. Cases like CVC from 88 and Adams v. Adams from 84 support keeping siblings together versus Re-B minors custody from 91, where separation was allowed.
Okay.
The strength of the child's attachment and bond to each parent is also highly relevant under this heading. Allington v. Allington from 1985 is an example.
And what about old assumptions about mothers versus fathers?
The sources emphasize that outdated presumptions based on gender or age are long gone. There's absolutely no legal presumption that young children or girls should automatically be with their mother or older boys with their father. Cases like Re-S, a minor custody, and Re-A minor custody, both from 1991, made that very clear.
Good. What else falls under need?
The child's attachment to their wider family can be important, particularly if the dispute is between, say, a parent and grandparents or another relative seeking orders. Re-K, a minor, wardship adoption, from 91, is relevant there. Related to this, and very importantly, the sources highlight that there is no presumption in law that a biological parent is necessarily better placed to meet a child's needs than a non-parent, like a long-term foster carer or a step-parent, especially in long-term care scenarios. The focus is on who can best meet the needs now and in the future. Key cases confirming this are Re-G, Children, from
No.
2006, House of Lords, and Re-B, a Child, from 2009, Supreme Court.
So biology's and destiny in the eyes of the law here.
Not in terms of a presumption, no. Educational needs are explicitly included and carry significant weight. Things like consistency of schooling matter. May v. May 86, Re-P A minor, Education 92, and Re-G 2012 all touch on education. And religious needs are also considered important, provided, of course, the practices involved are not harmful to the child's overall welfare. Re-G 2012 again, and Re-N a Child, Jehovah's Witness, from 2011, are examples.
Okay, needs covered. Number 3 on the list.
That's the likely effect on the child of any change in circumstances.
Stability, essentially.
Exactly. This factor leads courts to consider the value of stability and the potential disruption of change. They are generally reluctant to change the status quo, the existing arrangements, if that situation is broadly meeting the child's needs, unless the proposed change offers a clear and substantial improvement to the child's welfare. BVB, Custody of Child, from 85, and the Supreme Court case Re-B, a Child, from 2009, reinforce this. However, this status quo principle isn't compelling if no stable status quo has actually been established yet, Allington v. Allington again, or if the existing situation is clearly unsatisfactory or harmful to the child.
What if the status quo was created unfairly?
Good point. It's also important to note that this principle carries less weight if the status quo was established through wrongful means. For example, if one parent unilaterally removed the child without agreement, or a court order sometimes called parental child abduction, though not necessarily in a criminal sense here. Cases like Re-B A minor, residence order, ex parte, from 92, and Jenkins v. Jenkins from 1980 address this. Similarly, it's less compelling if one parent has deliberately alienated the child from the other parent, preventing a relationship from developing. Although courts are often hesitant to make orders trying to force contact in alienation cases, viewing such orders as a last resort if they might not be enforceable or could cause more conflict. Re-D A, residence order, from 2009, touches on this difficulty.
Right, the status quo isn't sacred if it's flawed or wrongfully created. What's the fourth factor?
Fourth is the child's age, sex, background, and any characteristic which the court considers relevant.
Okay, age and sex we've touched on, no presumptions. What about background?
Background is significant. It allows the court to explicitly consider the child's cultural, racial, and social background. This is particularly important in adoption and care placement decisions, where matching based on background is often considered beneficial for identity formation, although it's not always the overriding factor. Various Re-B cases concerning racial matching in placements explore this.
And any other characteristic.
That's a catch-all. It could include factors like disability, specific health conditions, particular talents, or even personality traits that significantly affect their needs or relationships. Religion can also be considered here or under background, especially if there are concerns that certain religious practices might be harmful to the child's welfare.
Harmful practices.
Yes, the sources mention cases where religious practices have been scrutinized in disputes, things like refusal of medical treatment, like Jehovah's Witnesses and blood transfusions, or practices alleged to be overly strict, isolating, or detrimental to education or social development. Cases like Wright v. Wright, Hewison v. Hewison, Re-T, Re-B and G, and Re-P, residence order, all touch on this difficult intersection of religion and welfare.
Right. Moving on to number 5. Harm. That sounds crucial.
Yes, the fifth factor is any harm which the child has suffered or is at risk of suffering.
How is harm defined here?
The Act defines harm in the same way it does for initiating care proceedings under Sections 105 and 31(1). It covers both actual ill treatment, which includes physical, emotional, or sexual abuse, and the impairment of a child's health or development. Development here means physical, intellectual, emotional, social, or behavioral development. Let's repeat that concept. Harm.
Harm.
Evidence of harm is, obviously, often the reason for court intervention in the first place. A history of causing harm will severely impact a parent's case for having the child live with them. However, past harm by a parent doesn't automatically mean they should have no contact at all. Courts might still permit supervised or restricted contact if they deem it to be in the child's overall welfare to maintain some kind of relationship, carefully balancing the risk against the potential benefit. There's a tension here, seen in contrasting cases like CVC, HVH, and LVL versus RE-R.
And what about domestic abuse between the parents?
That's specifically highlighted in the sources. There's increasing judicial recognition now that exposure to domestic abuse is damaging for children, even if the violence or abuse is not directed at them personally.
Just witnessing it is harm.
Exactly. Witnessing abuse between parents or just living in an environment where it occurs is now understood as causing significant emotional and psychological harm to a child's development. This understanding is reflected in recent case law concerning contact arrangements in the context of domestic abuse cases like REL, RE-V, RE-M, and RE-H are mentioned.
That's a really important development. Okay, checklist point number 6.
That is, how capable each of the child's parents and any other person in relation to whom the court considers the question to be relevant is of meeting the child's needs.
So comparing the adults.
Pretty much. This point requires the court to assess and compare the abilities of all the relevant adults, usually the parents, but potentially grandparents, other relatives, step-parents, prospective adopters, to meet the child's physical, emotional, and educational needs as listed back in point 2. The court will look at practical parenting skills, stability, financial security, emotional warmth, willingness to promote contact with the other parent, unless there's a good safeguarding reason not to, and just the overall capacity to provide a nurturing environment. DeCoco v. Milne from 1983 is often cited as an example of courts contrasting the care capabilities of parents.
Makes sense. And the final point on the checklist, number 7.
The seventh and final mandatory point is the range of powers available to the court under this act in the proceedings in question.
What does that mean?
It basically reminds the court that they have various tools in their toolkit under the Children Act to craft orders that actually work and serve the child's welfare. They aren't limited to a simple yes-no decision about who the child lives with or sees.
Okay, like what kind of tools?
Powers include things like attaching specific conditions to Section 8 orders, for example, requiring parents to attend parenting classes, or specifying handover locations or times. There's the power for the court to make a Section 8 order for someone who didn't even apply if the court thinks it's necessary for the child's welfare. That's Section 10b. They can make a family assistance order under Section 16, which provides short-term support and advice from a social worker or a CAFCAS officer to help the family manage contact or other issues. Or, in really high-conflict cases, the court can impose a restriction under Section 9114, preventing further applications to the court without first getting permission to stop vexatious litigation. This checklist point encourages the court to think creatively about how to best implement the welfare decision using the available legal mechanisms.
Right, so consider all the options before deciding. Okay, that's the core paramountcy principle and the detailed checklist. But the Children Act 1989 introduced a couple of other key guiding principles for courts too, didn't it? One being about delay.
Yes, absolutely. Section 1, subsection 2 of the Act states that the court shall have regard to the general principle that any delay in determining a question about a child's upbringing is likely to prejudice the child's welfare.
Delay is bad for kids.
That's the underlying idea. It reflects the understanding that uncertainty and prolonged court proceedings can be very damaging for children, disrupting their lives, causing anxiety, and leaving them in limbo. The principle is intended to encourage courts and everyone involved to deal with cases as quickly as is reasonably possible.
But it's not an absolute ban on delay.
No, it isn't. The sources clarify that it doesn't mean cases can never be adjourned or that delay is always bad in every single instance. Sometimes, a short managed delay might actually be necessary or even beneficial for the child's welfare, for example, to allow for crucial assessments to be completed, or perhaps for parties to attempt mediation. Cases like C.V. Solihol, MBC from 93, and Re-B, A minor, contact, interim order, from 94 show instances where delay was permitted because it served a specific positive purpose. Contrast that with cases like BVB minors, interviews and listening arrangements from 94, and Re-A and B minors from 95, where undue delay was criticized. The key question is whether any delay is necessary and ultimately serve the child's overall best interests.
Okay. There's also the no-order principle, which sounds like a pushback against courts automatically assuming they need to make a formal order in every case.
Exactly right. The Law Commission's report that led to the 1989 Act noted a concern that courts sometimes seemed too quick to impose formal orders, perhaps unnecessarily interfering in family life. So Section 1, subsection 5, introduced the no-order principle. It states, a court shall not make an order under the Act with respect to a child unless it considers that making the order would be better for the child than making no order at all.
Is an order actually better here?
That's the question it forces the court to ask. It requires the court to pause and genuinely consider if judicial intervention through a formal order is truly necessary or beneficial, or if the family dynamics are such that an order might actually cause more problems, more conflict, more rigidity than it solves. This principle applies to all orders under the Children Act, but interestingly, not to adoption orders.
Okay. Does it get used much?
Oh, well, the sources give an example in BVB, Grandparent Residence Order, from '92, where a court found making an order was better, even though there wasn't an active dispute at that moment, simply to provide legal certainty and formalize the arrangements for the grandparent caring for the child. However, the principle needs careful application. Courts have sometimes been criticized for seemingly overlooking Section 1.5, as mentioned in RIO, A minor, Education Procedure, from '92. But more recently, cases have reinforced that it is wrong for a court to make no order if there is a clear dispute between the parties that actually needs a judicial decision based on the child's welfare. RAP, Contact, Grandparents, from '96 made that clear. Similarly, if a court's decision to make no order effectively results from failing to properly resolve a fundamental parental dispute in the child's best interest, that decision can be successfully appealed, as seen in Re G. Children from 2005. The sources recommend Activity 9.5, which prompts you to look at various cases and trace how judicial attitudes seem to have differed over time in applying both the checklist and this no-order principle.
So a principle to apply thoughtfully, not automatically, right? So the welfare principle is central. It's guided by the checklist, tempered by principles of no delay and no order. But despite being the cornerstone, we know it faces significant criticism. What are the main arguments against relying so heavily on this principle?
Yes, it's definitely not universally praised, despite its centrality. The sources outline several key criticisms, often drawing on the work of prominent academics like Jonathan Herring. There are about 7 main points they raise.
Okay, let's hear them.
First, there's the narrow perception criticism. Critics argue the legal focus on welfare in individual court cases is just too narrow. It tends to ignore wider systemic issues that profoundly affect a child's well-being, things like poverty, the quality of housing available, failures in public services like education or mental health support. These are often shaped by political decisions way beyond the court scope, but they hugely impact welfare. King and Piper are writers associated with this view.
So the court process ignores the bigger picture.
In a sense, yes. Second, it's an uncertain criterion. This is a major one. Welfare is inherently vague, it's hard to define precisely, and even harder to predict consistently how a judge will interpret it in a specific case. Critics like Mnuchin argued it requires judges to have almost clairvoyance to know what's truly best long-term.
Right.
This uncertainty gives judges immense discretion, which can lead to inconsistent decisions between cases. And it makes it incredibly difficult for parents to know what outcome to expect, which hinders negotiation and settlement outside of court because the goalposts seem unclear. That's the uncertainty argument.
Okay.
Third, it can act as a smokescreen for bias. Following on from the uncertainty, critics argue that the vagueness of welfare allows it to act as a smokescreen. It lets judges potentially hide their own subjective values, their personal biases or prejudices about parenting styles, gender roles, lifestyles, or social norms behind the seemingly objective language of the child's best interests.
So bias hiding in plain sight.
That's the concern. Fourth, it increases costs. The comprehensive, fact-specific nature of a full welfare assessment, often requiring extensive evidence, maybe multiple expert reports, detailed analysis of every single checklist factor, inevitably makes court proceedings longer, more complex, and therefore significantly more expensive for the families involved or for the state if legal aid is involved.
Makes sense. Number 5.
Fifth, it ignores adults' welfare. The paramountcy principle means exactly that. The child's welfare is paramount, above all others. Therefore, the welfare of the adults involved, particularly the parents, is given no explicit weight in itself. While parental capabilities and circumstances are considered under the checklist because they impact the child, the parent's own needs, their happiness, their career prospects, even their suffering, are legally secondary or technically irrelevant except as they affect the child. This can feel deeply unfair to parents and, ironically, can even indirectly harm the child if the primary carer is severely negatively impacted by a court decision that ignores their well-being.
That's a really interesting point.
Sixth, it can lead to unrealistic outcomes. Sometimes what a court determines is theoretically best for the child's welfare might just be practically impossible to achieve due to real-world constraints, lack of suitable housing, limited financial resources, the emotional state or capacity of the parents involved. The principle doesn't always fully account for this gap between the ideal and the practical reality.
And the 7th criticism.
Seventh, and this is a major modern criticism, it fails to account for children's rights. The argument here is that the welfare principle, which is ultimately decided by adults, judges, doesn't fully recognize children as independent rights holders with their own agency and specific rights under international law, like the UN Convention on the Rights of the Child, or indeed under domestic law, like the Human Rights Act. It prioritizes an adult determination of best interests over, potentially, the child's own inherent rights, including the right to make decisions where they are deemed competent.
So welfare isn't the same as rights.
Not necessarily, and that's the tension. Despite these strong criticisms, though, the sources also provide examples showing the principle's continuing practical importance. A case like G, Children, Intractable Disputes from 2019, demonstrates how, in really complex, long-running, high-conflict disputes between parents, the welfare principle, for all its flaws, remains the necessary legal tool for courts to try and cut through the conflict and find some path forward for the child, however difficult that assessment might be.
Right, it's the tool they have. So if the welfare principle does have these flaws, what are the potential alternatives that have been suggested for governing child law disputes instead?
Well, the sources discuss several different approaches that have been proposed over the years, either to replace or perhaps supplement the welfare principle.
Okay, such as?
One idea is having a legal presumption in favor of the primary carer. This approach would start from the assumption that the person who has been the main hands-on caregiver for the child before the dispute should generally continue in that role, prioritizing stability, unless there's a strong reason related to harm not to. That's the primary carer presumption.
Okay, another.
Another is a presumption favoring joint residence or shared parenting. This would assume that children generally benefit from spending significant time living with both parents after separation, promoting shared parenting unless it's clearly impractical or harmful. Joint residence parenting presumption.
What else?
There's also an emphasis on promoting cooperative parenting. This approach focuses on legal frameworks and support services that encourage or even require parents to make joint decisions and resolve disputes collaboratively, ideally outside of the adversarial court system, focusing on cooperative parenting.
Any more radical ideas?
Some more radical proposals have even suggested allowing children themselves to decide who they wish to live with after parental separation, once they reach a certain age or level of maturity, giving them full autonomy.
Wow.
And even more controversially, perhaps more theoretically, some have suggested resorting to methods like tossing a coin to decide residence in finely balanced cases, arguing it treats parents absolutely equally and perhaps highlights the perceived arbitrariness or difficulty of making fine distinctions in complex welfare assessments.
Tossing a coin. Right.
Beyond these purely legal principles, the sources also highlight the increasing importance of informal dispute resolution methods, things like mediation. This has become particularly relevant since the LA's PO Act in 2012 dramatically reduced legal aid for many private law children disputes. There's a much greater push now towards resolving matters outside of court.
But is welfare protected there?
That's the potential concern. Does mediation or negotiation always ensure the child's welfare is as rigorously prioritized and scrutinized as it would be in formal court proceedings, where the judge is bound by Section 1 of the Children Act? It's a valid question.
So these alternatives exist, but they have their own issues.
Exactly. While each of these alternatives has its own set of supporters and critics, the sources acknowledge their value lies mainly in prompting reflection on the existing system and clearly highlighting the perceived shortfalls or difficulties of the paramount welfare principle.
Okay. Finally, let's look at the interaction between the Human Rights Act 1998, the HRA, and the welfare principle. Does giving parents explicit human rights, particularly the right to family life under Article 8, create a fundamental conflict with the idea that the child's welfare is paramount?
This is a really significant area of debate, and legally quite complex. The HRA incorporates rights from the European Convention on Human Rights into UK law. Article 8, guaranteeing the right to respect for private and family life, is the key one here. Parents obviously rely heavily on this right in disputes concerning their children. The big question is, how do you reconcile a parent's legally protected right to respect for their family life with the domestic legal principle that the child's welfare is paramount, potentially overriding the parent's wishes?
So, is there a conflict? What did the tort say?
Well, judicially, when this potential conflict was first considered seriously around the time the HRA came into force, senior judges like Lord Templeman in Re KD, a minor ward termination of access, back in 1998, essentially stated they were compatible. Lord Oliver, in the same case, viewed any apparent conflict as merely semantic, a matter of wording.
So the judges said, no problem.
That was the initial high-level view. However, academic commentators like Herring, whom we mentioned earlier, argue that a genuine conflict does exist in certain scenarios, where promoting the child's welfare directly infringes on a parent's Article 8 rights. The prevailing judicial position now, though, as reflected in most recent cases, tends to be that the paramountcy principle is considered compatible with the HRA.
How do they square that circle?
The European Court of Human Rights itself, in cases like Scott v. UK from 2000, has stated that the interests of the child are of crucial importance within the balancing exercise required under Article 8 when considering interference with family life. So, the child's interests are given significant weight even within the human rights framework. Furthermore, our own Supreme Court in Rebi, Care Order Proportionality, in 2013 indicated that the Children Act 1989 should be interpreted and applied in a manner that is informed by the ECHR jurisprudence. It suggests they should work together.
Informed by. Okay, what about this proportionality test used in care cases? Does that apply in disputes between parents?
That's part of the ongoing discussion. In public law care cases, where the state seeks to intervene, courts apply a rigorous proportionality test under Article 8 to ensure the intervention is necessary and justified. There's been debate about whether that same explicit test should also be applied in private law disputes between parents.
And the answer?
Well, the Court of Appeal in Race C, Internal Relocation, in 2015 considered this directly and felt there was no inconsistency of principle or application between the welfare test and Article 8 in private law cases. Their reasoning was that a proper analysis of the best interests of the child under Section 1 necessarily involves a careful examination of the parent's wishes and their interest, precisely because the parent's situation and feelings have such a direct impact on the child's welfare. So the argument is that parental Article 8 rights are considered within the welfare analysis, rather than requiring a separate, distinct proportionality test. However, the sources indicate the debate on whether a distinct test is needed probably continues, particularly among academics.
Right, and it's not just parents who have rights.
Exactly. It's crucial to remember that children are also rights holders under the HRA. Article 8 applies to them too, their right to family life, their private life. So sometimes the court isn't just balancing the child's welfare against parental Article 8 rights, but potentially balancing a parent exercising their Article 8 rights against the child exercising their own Article 8 rights. It can get very complex.
Definitely. And you mentioned circling back to Gillick competence here.
Yes, the sources use activities 9.7 and 9.8 to really explore the tension between welfare, a child's capacity, Gillick competence, and rights, particularly in the medical context, all viewed through the HRA framework. These activities prompt questions like, how is Gillick capacity actually determined? Answer, it's about understanding the specific treatment and its implications, not general intelligence. Can a Gillick competent child refuse life-saving treatment? Answer from the sources referencing REW medical treatment. Generally no, as courts and parents can usually override this based on the child's welfare. Can someone with parental responsibility override a 16-year-old's or a competent child's consent to treatment? Answer based on REW and ABVCD. Generally, yes, the parent's right to consent continues unless perhaps the parent is trying to override a competent child's beneficial decision. Can the court override? Answer, yes, the court's inherent jurisdiction allows it to override both parental and child decisions regarding medical treatment if it's deemed in the child's best interests. And conversely, can anyone under 18 refuse treatment if a parent or the court has consented? Answer, generally no.
So welfare often trumps autonomy, even competent autonomy.
In those critical situations, yes. These points really highlight that even within the HRA framework, the child's welfare, as determined ultimately by the court, can override their autonomy or a parent's wishes, revealing the complex hierarchy and the intense balancing act involved.
We have covered a huge amount of ground today. Wow. From the historical roots right through to modern complexities and criticisms. For those listeners studying this, perhaps for an exam, how do you bring all these different pieces together and actually apply them to a practical problem question?
That's the key transition, isn't it? Moving from understanding the concepts in isolation to applying them in combination, just as you'd need to in an exam scenario. The sources are helpful here, guiding you on how to approach the sample questions provided, and they really are excellent practice.
So take the first sample question about Mary John, Laura, who's 13 and pregnant, and Ben, who's 9. How would you tackle that using what we've discussed?
Right. First, you identify the core issues. This is clearly about Section 8 orders, like specific issue orders regarding the abortion or prohibited steps regarding the school, and other upbringing issues. So straight away, welfare is paramount under Section 1.1. Then, because these are likely to be contested applications for Section 8 orders, you must apply the welfare checklist from Section 1.3.
The 7 points.
The 7 points. And crucially, you have to consider each child individually against those checklist factors. Laura's situation immediately flags the need to discuss her wishes and feelings, point one, her age and understanding, and specifically Gillick competence regarding her medical decision about the abortion. You'd need to analyze if she likely has capacity. For Ben's school, you'd focus more on needs, point two, effective change, point three, background, point four, and parental capability, point six. You also need to remember to consider the no order principle, section 1.5. Is a court order actually better than no order for either issue? And the no delay principle, section 1.2, is always relevant context. Plus, of course, you'll need your knowledge from other parts of the course about what section 8 orders actually are and how they operate.
So applying multiple principles and the checklist systematically to each child and each issue.
Precisely. Now, the second sample question is different. It asks for a critical assessment of whether the UK needs a Charter of Children's Rights. That's more of an essay-style question.
How would you approach that one?
This is where you bring in all the criticisms of the welfare principle we discussed, especially point 7, about it failing to adequately account for children's rights. You discuss the current landscape. Children do have rights under the HRA, but these rights aren't explicitly centered or paramount in the same way that welfare is in the Children Act. You could use examples, perhaps from other course materials or general knowledge, where children arguably lack autonomy over decisions affecting them, like historical corporal punishment or being subjected to paternity tests against their will. Discuss the role of the checklist factor about wishes and feelings. Does giving children a voice through the checklist go far enough, or is it still ultimately filtered through adult interpretation of welfare? Use Gillick competence as an example of where the law does recognize capacity, but then critically discuss its limitations, like the inability of a competent child to refuse life-saving treatment if a parent or court consents. Your conclusion would need to weigh things up. Should rights override welfare? Should welfare override rights? Or does the current system, where welfare is paramount but must be interpreted compatibly with the HRA, strike the right, albeit difficult, balance? You draw on the cases we've discussed concerning HRA compatibility, like Re-KD, Scott, Ray B, Re-C.
Those application examples really show how all these different elements, principles, cases, criticisms, rights fit together in practice. And as you mentioned, reviewing the reflect and review sections and actively attempting the activity questions in the source materials sounds like a fantastic way to test understanding and get ready.
Absolutely. And the repetition of key case names, JVC, Gillick, Re-A, Re-B, Re-G, and concepts like paramountcy, welfare checklist, parens patriae, harm, no order principle, Gillick competence, throughout our discussion is entirely intentional. It's meant to help lodge these key points in your memory for when you need them most.
We have indeed covered a lot today. Let's quickly recap. We started with the absolute core, the paramount welfare principle in Section 101 of the CA, 1989, its history back to parens patriae and the crucial case of JVC. We looked at the older jurisdictions of wardship and inherent jurisdiction, understanding their powers, their limitations, and that golden thread of welfare running through wardship.
Right.
Then we identified the crucial situations where the welfare principle is not paramount, those exceptions you absolutely need to know.
Very important.
We dove into the broad, sometimes difficult meaning of welfare itself, including that idea of a global holistic evaluation, and wrestled with applying it in truly tragic cases like the conjoined twins, Rie.
Difficult stuff.
We walked point by point through the mandatory welfare checklist in Section 1.3 and explored the nuances of each factor, including the complexities and limits of Gillick competence.
The 7 points, yeah.
We covered other important principles like no delay from Section 1.2 and the no order principle from Section 1.5. We tackled the significant criticisms leveled against the welfare principle and briefly considered some alternative approaches,
Including coin tossing.
And finally, we examined the complex interaction between welfare and human rights, particularly Article 8 of the ECHR, and how courts are trying to navigate that balance.
It's a vast and intricate area of law, definitely. But hopefully breaking it down systematically like this has made it feel a bit more manageable for everyone listening. And perhaps as you continue to study and engage with this material, here's a final provocative thought to mull over. Given the inherent uncertainty of the welfare principle, the valid criticisms that it can overlook the needs of adults and perhaps doesn't fully center children's own rights, and the ongoing debate about proportionality under the Human Rights Act, is making welfare the paramount consideration truly the best possible foundation for all child law decisions today? Or could perhaps a first consideration standard, or maybe a legal framework that gives more explicit and potentially equal weight to children's defined rights alongside welfare, offer a more principled or maybe even a more practical way forward for the future of child law? It's certainly something worth thinking about as you deepen your understanding.
That is a powerful question to reflect on. Is paramountcy still fit for purpose in every context? Thank you for joining us for this deep dive into the welfare of the child. We really hope it's been incredibly helpful for your understanding and, of course, for your preparation. A final reminder that this deep dive was based entirely on educational materials made available by the University of London, strictly for education purposes, and it was brought to you by Sinorbit Academy, Sri Lanka.
Great resources.
And once more, truly, from both of us, good luck for your exams.
Yes, very best of luck to everyone tackling this topic.
We'll see you next time on the Deep Dive.